I think not. We did it for practically only
May
for
please.
episode.
May please. My lord, this is a writ appeal having regard to my lord the urgency, my lord. So prayer was made.
Yes, sir, we understand that.
Yes, my lord. The medical admission course, my lord. In fact, the first counseling, my lord, was over, and by dint of my lord the first counseling, he figured my lord position in the merit select list, my lord. And subsequently, my lord, her admission was refused, my lord. And even thereafter, my lord, she approached this honorable court. Then this honorable court passed an interim order, my lord, directing to my lord keep one seat vacant in the department of my lord radio diagnosis at Silchar Medical College. Eventually, my lord, the honorable single judge was pleased to dismiss the writ petition, and this is how my lord the appeal is before your lordship, my lord.
Yes.
In fact, by 22nd, my lord, yesterday, as in terms of the educational notice, my lord, the second counseling is perhaps, my lord, over, and today is the date for declaration of the result. So therefore, my lord, some interim order or disposal of the writ appeal may be necessary, my lord. Now, having said that, my lord, before proceeding further to the impugned judgment, may I briefly state the facts, my lord. My lord, the petitioner, my lord, she has applied, my lord, against the quota of SHQ, my lord, State Health Service quota, my lord, in the my lord NEET PG 2024. And my lord, under this, my lord, particular quota, MBBS degree holder who has been serving under the state government, under the Health and Medical, my lord, Family Welfare Department or NHM, my lord, if she has completed 5 years, my lord, in terms of the rules of the 21, my lord, by 31st May 2024 or the my lord year of admission, she is eligible, my lord, to apply. Now, what has happened, my lord? In 2017, she had completed her MBBS, my lord, course. And thereafter, my lord, she had undergone 1 year compulsory rural posting with effect from 9 April 2018 to 8 April 2019. And to this effect, my lord, a competent authority has annexed, my lord, issued a certificate, which is annexed, my lord, to the writ appeal. Subsequent thereto, my lord, after completion of 1 year compulsory service, my lord, she was appointed, my lord, as a medical and health officer grade 1 by a notification issued by the government on 23/10/2019. And she joined, my lord, therein on 31/10/2019. Thereafter, my lord, she is continuing till date, my lord. And to this effect, my lord, another certificate, my lord, is issued by the, my lord, competent authority, indicating that as on 2nd November 24, my lord, she has completed 5 years, my lord, 4 days. Now, my lord, what happened? The petitioner, pursuant to,
That is as on
my lord, 2/11/24, there is a continuous service of 5 years.
5 year 4 days.
5 year 4 days, my lord. Page 93, annexure 5 to the writ petition.
Okay.
Then subsequent thereto, my lord, the petitioner, the writ appellant, my lord, she applied for the NEET PG 2024 in terms of a notification, my lord, notice at page 94, annexure 6 to the writ petition, my lord, dated 9/11/23. And by this notice, the various, my lord, schedule of the various examinations, my lord, including the NEET PG 2024 was notified, and NEET PG 2024 was scheduled to be held, my lord, on 3rd March 24. That is page 94, annexure 6. This document may be necessary, my lord. So I'm referring this document to your lordships, my lord. My lord, this particular schedule was subsequently rescheduled, and another notice was issued, my lord, at page 95, 9 January 24. And by this, my lord, notice, the PG NET 2024 was scheduled to be held on 7 July 24. This also subsequently, my lord, this was rescheduled, and eventually at page 96, annexure 8, that was issued, my lord, by the National Board of Examinations. And the, my lord, date of examination was scheduled as 11th August 24. And eventually, this is the date on which, my lord, the examination was held. Thereafter, my lord, admit card was issued to her. She had, my lord, participated in the entrance examination and she was able to crack, my lord, the NEET PG 2024. Now, my lord, in terms of the rule, out of the total seats of the medical colleges of Assam, 50% is allotted, my lord, to the All India quota and 50%, my lord, in respect of the, my lord, state, my lord, quota. Out of that state quota, my lord, in terms of Rule 7 of the Medical Colleges of Assam Rules 2021, 40 seats, my lord, are earmarked for the SHQ quota in terms of Rule 2021. And the, my lord, state government, rather, my lord, the Director of Medical Education Assam, in terms of the integrated merit list, who have cracked the NEET, my lord, it prepares, my lord, a provisional revised select list. And the petitioner, she was able, pursuant to the first counseling, my lord,
Figure 1.
she was able to, my lord, figure herself in the select list at serial number 401. If your lordship comes to the select list, my lord, at page, my lord, 48. The select list starts from page 35, Annexure 1. It is dated 26/11/24. Serial number 401. That is, my lord, Jennifer Kaifi Ahmed. This is writ appellant, writ petitioner, category general. And your lordship will see the quota SHQ, state health quota.
Yes.
And the department is radio diagnosis, Silchar Medical College, Silchar.
40 seats.
And my lord, I may hasten to add that amongst, my lord, the state health quota, my lord, candidates who were able to secure a seat,
You
my
are
lord,
the
she was at
first.
the top of the list
Yes.
and others followed her. Now, my lord, in terms of the notice, my lord, of the DME, Director of Medical Education Assam, which is annexed as page, annexure, my lord, 12 of the writ petition, page 101. The date of document verification was fixed, my lord, for the candidates securing, my lord, place in the select list. And in terms of her, my lord, merit, my lord, 574. Serial number 401, her, my lord, place in the select list is 574. That was fixed on 29/11 in terms of page, my lord, 101. So on 29/11, when the petitioner, my lord, appeared before the Director of Medical Education Assam for verification of the documents, my lord, she was informed, my lord, that admission is refused to her and thereby she could not be allotted the seat. Now, in this context, my lord, no formal letter or order was issued. I was verbally informed, my lord, and thereafter, my lord, the petitioner appeared before this honorable court filing the writ petition. And my lord, my learned friend also in the affidavit has also made it clear that no formal order was passed on the declaration form. It was, my lord, annexed. Now, before proceeding further, my lord, I may take your lordship to the rule, which is, my lord, which was holding the field at page 104 and which governs, my lord, the admission, my lord, into the postgraduate medical courses in Assam. If your lordship comes to page 104, my lord, this is the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Course Rule 2021. Now, the relevant rule is Rule 7, my lord. If your lordship comes to page 107. Reservation of seats. The following quota reservation of seats shall be applicable in respect of admission to the postgraduate degree and diploma course in medical colleges. My lord, we are concerned with 7(1)(c), SHQ, State Health Service Quota seats. 40 seats, 37 degree and 3 diploma out of total state quota seats shall be reserved in each session for the doctors appointed in the state health service on regular basis on the recommendation of the APSC, MHRB, and who have completed, my lord, this is important for me, who have completed 5 years or more service in rural areas. However, for counting the experience of 5 years of service in rural areas, period of work under Regulation 3F APSC, then 7DH MRHB rules, service under any society agency created by the state government or NHM shall be counted. The applicant must complete the required period of service in rural areas on or before 31st May of the year of admission, and a certificate to this effect shall be submitted in the format at Appendix 3 along with the application form for postgraduate counseling. So, my lord, the appendix 3, my lord, the certificate should be, my lord, annexed. My lord, I have annexed, my lord, 2 certificates, my lord, for ready reference, just to draw your lordship's attention. One is at page 89. This, my lord, indicates that I have page 88 and 89. I have, my lord, completed 1 year, my lord, rural posting in the rural areas, my lord. This is 1 year from 9/4/2018 to 8/4/2019. Page 88 and page 89. And this, my lord, certificate, my lord, are issued by the competent authorities, Joint Director of Health Services. And the another certificate, which your lordship will find at page 93, this is in the appendix 3. This is by the Joint Director of Health Services. It
Page
says,
number
my lord,
93.
page 93, this was annexed as Annexure 5 to the writ petition, my lord. This is to certify that Dr. So-and-so has been working in regular service in Gorajan SD under Singimari BPHC, Nagaon, situated at Gorajan village of Singimari subdivision in the Nagaon district, Assam, with effect from date of joining 31/10/19 to till date, for a period of 5 years, 4 days,
But
continuously
as
and
per
satisfactorily.
this is not, it doesn't appear to be in accordance with the rule you cited, the
Right.
91C,
Right.
that is at page 107.
My lord.
It says continuous service, but these are two different service.
My lord,
Page 89 and 93, they are two different service.
my lord, 2 different services. My lord, what I'm trying to say, the earlier one is also, my lord, a rural posting under, my lord, Rule 7. And it says, my lord, under state government or NHM or whatsoever. This is 1 year service. And this one is, my lord, continuous 5 years up to 2nd of November 24. So, my lord, if we take into account both the services, then, my lord, it is about 6 years. My lord, I'll come to that. Now, in terms of, my lord, the Rule 7, 7(1)(c) says, my lord, 5 years of service, 31st May. So,
5 years
if
of continuous service. No.
that is not continuous service. In terms of 21, my lord, not continuous service. If your lordship again come, my lord, to the rule, page, my lord,
107.
oh, yes, page 107, it does not say about continuous service.
Yes.
No, my lord. I'm reading it out. Who have completed 5 years or more service.
Yes.
5 years or more service in rural areas. In terms of, my lord, this particular rule, 21. And the cutoff date,
This is 21.
21.
Okay.
Well, I'm coming to the amended, my lord, amended portion.
Okay. You are
Yes.
right. You are right.
Yes, yes, my lord. Now,
You are right.
my lord, correct.
Hmm.
Now, my lord, the cutoff date is 31st May, my lord, of the admission year.
Hmm.
Now, if we take into account only, my lord, the first certificate or the second certificate, then up to 31st May of this admission year, my lord, there is a continuous period of or period of 4 years, 7 months cutoff date. And if we add, my lord, the earlier, then it is 5 years, 7 months up to 31st May, my lord, 2024. Now, in the meantime, my lord, by the time, my lord, the government of Assam had amended the rule, my lord, that your lordship will find at page 118. Amendment of Rule 7. Your lordship will come to, my lord, 2 in the principal rules.
Yes.
My lord, this is dated 13 March 24. Your lordship will take note of 2 aspects of the matter. 13 March 24 and the serial number 2, my lord, subsection 2 of section 1, my lord, the date of operation, how it will come into effect, my lord. This, they shall come into force from the date of their publication in the official gazette. So therefore, this is 13 March 24. It will have a prospective effect. Henceforth, now your lordship will see what, my lord, has been changed. Amendment of Rule 7. Your lordship will come to section 2, 2.1. in the principal rules, in Rule 7, in Sub-Rule 1, after clause 6, in last line after word, bracket, seats, the punctuation mark shall be inserted and thereafter following proviso shall be inserted, namely, state provided that state quota seats shall be reserved in each session for the doctors appointed in the state health services on regular basis on the recommendation of the Assam Public Service Commission or Medical and Health Recruitment Board and who have completed 5 years or more than 5 years of continuous service. Now, by this amendment, the element of or the requirement of continuous service has been brought in.
Yes.
On this ground, my lord, as it appears from the affidavit in opposition, my lord, my admission has been refused, saying that as on 31st May, if we go by the rules, 31st May 2024, you don't have a continuous period of 5 years.
Yes.
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 Now, while proceeding further, I may draw your lordship's attention, which may be relevant. Another document, my lord, at page 99, Annex 11 to the writ petition. My lord, this document has been issued by the Secretary to the Government of Assam, Health and Family Welfare Department. This is, my lord, NOC issued on 27/9/24 to the petitioner along with others for appearing in the postgraduate entrance examination 2024. And the name of the petitioner, it appears at serial number 11. Man.
Yes.
So therefore, your lordship will see by the amended rule, the requirement of rural area has been excluded and 5 years continuous service has been brought in.
Yes.
Now, my lord, my respectful submission is that this amended rule could not have been applied, my lord, in respect of the appellant to refuse, my lord, the seat which she have secured by dint of her merit and appearing, my lord, in the select list at serial number 401 against radio diagnosis in the Department of Silchar Medical College. My lord, before proceeding further, my lord, this cutoff date of 31st May, my lord, is prescribed due to the reason your lordship is aware that normally all the PG courses admissions are complete by 31st May and the classes, my lord, commence from first week of June, my lord. Here, my lord, this time what happened due to the anomalies creeping into the undergraduate, my lord, NEET examinations, eventually, my lord, all the examinations deferred. And by December 31st of this year, the admissions would be concluded in terms of the educational notice, my lord. And therefore, the classes would commence, my lord, from January 25. So this is one of the aspect of the matter which your lordship would also be required to, my lord, take care of while considering, my lord, the cut-off date. And another notification, my lord, is there of the National Board, which says that the cut-off date would be, my lord, 15th August. So we find, my lord, three different dates and circumstances. One prescribed by the rule, 31st May. Another by the notice of the, my lord, National Board, prescribing the cut-off date as 15th August. For ready reference, my lord, I may draw your lordship's attention to that notice. At page 96, my lord. Eventually, in view of this notice, the examination was held on 11th August 24. Page 96, serial number 2, my lord, 3. The cutoff date for the purpose of eligibility to appear in the NEET PG 2024 shall continue to be 15th August 24. So this is by the National Board of Examination.
Yes.
Now, on these premises, my lord, I would make my submissions, respectful submission, my lord. My first respectful submission is the amended rule could not have been applied in respect of, my lord, the petitioner or to refuse admission, my lord, in respect of, my lord, the seat which she have secured by dint of her merit. The reason is, my lord, there is a constitution bench judgment
7/11.
on 7/11/24, which says, my lord, that once the selection commences from, my lord, from the date of commencement until, my lord, the filling up of seat or the post, this is a selection process. And midway through, my lord, the rule cannot be amended and thereby applied in a retrospective manner. Now here, my lord, this is a constitution bench judgment. Reference, my lord, was made before the constitution bench judgment. There are two conflicting judgments, my lord, of the Honorable Supreme Court. One in K. Manjusri's case, another in Subhash Chandra Marwaha case, my lord. Now, K. Manjusri, my lord, has held that so far as the basic qualification is concerned, that cannot be amended and applied in a retrospective manner. My lord, if I take your lordships to the reference part, my lord, that would be more easy to understand. Page, my lord, 8 of this judgment. The page number your lordship will find down below. Sorry, my lord. Firstly, your lordship come to the reference. This is at page, my lord, 3. What was the reference, my lord, in fact?
Yes.
Reference. A 3-judge bench of this court, while accepting the salutary principle that once the recruitment process commences, the state or instrumentality cannot tinker with the rule of the game, insofar as the prescription of eligibility criteria is concerned, wondered whether that should apply also to the procedure for selection. In that context, doubting the correctness of a coordinate bench decision in K. Manjusri for not having noticed an earlier decision is Subhash Chandra Marwaha, so-and-so dated 28 March 2013, it was directed that the matter be placed before the Chief Justice for constituting a larger bench for an authoritative pronouncement on the subject. Now, pausing for a moment, my lord, K. Manjusri, it dealt with, my lord, the eligibility criteria. And Subhash Chandra Marwaha, my lord, it dealt with the procedure for selection. There were two conflicting judgments. Now, Manjusri said that the basic qualification or the eligibility criteria, you cannot change midway through. Now, Subhash Chandra Marwaha said it can be, but so far as the procedure for selection is concerned, that can be done. Now, if your lordship proceeds further, in respect of the judgment, I take your lordship, my lord, to page 8. Para 5. Your lordship has got it, my lord.
Yes.
Page 8, para 5. In various judicial pronouncements, the law governing recruitment to public services has been colloquially termed as the rule of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an off-quoted legal phrase that the rules of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall in two categories. Now, here, my lord, it is made clear. One, which prescribes the eligibility criteria, essential qualifications of the candidates seeking employment, and the other, which stipulates the method and manner of making selection from amongst the eligible candidates. So one relates to, my lord, the basic qualification, and the other is, my lord, the manner and method. Then para 7 and 8 also may be, my lord, necessary. My lord, we may go directly to the, my lord, conclusion part, but before that, I will invariably take your lordships to page 11 also. Now, this para 13, my lord, page 11, the Honorable Supreme Court has made it clear when the process starts or commences, my lord. So the starting point, my lord, is important, para 13, page 11. The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps like inviting applications, scrutiny of applications, rejection of defective applications or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of list of successful candidates for appointment. So therefore, my lord, once the advertisement or initial notice is issued, the process commences.
In our case, 7-11.
And thereafter, there may be various stages for inviting applications, scrutiny of application, rejection of defective application, etc. These are stages, my lord. And until, my lord, the posts are filled up, my lord, this is considered to be a, my lord, selection process. My lord, conclusions are drawn at, my lord, page 25, para 42, by the reference court, my lord, Constitution bench. Recruitment process commences from the issuance of the advertisement, calling for applications, and ends with filling up of vacancies. So this is, my lord, a course. It will end only when the vacancies or seats, my lord, or posts are filled up.
7-11.
Secondly, my lord, number 2, eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rule so permit or the advertisement which is contrary to the extent rule so permits. Even if such change is permissible under the extent rule or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Now, the first word starts with, my lord, eligibility criteria. So it cannot be changed. And, my lord, more so, the rule, my lord, which has amended the eligibility criteria, that must specifically speaks, my lord. It must contemplate that it can be applied in a retrospective manner. My lord, 3, the decision in K. Manjusri lays down good law. So Manjusri said, midway through, you cannot change the eligibility criteria or the basic qualification. And is not in conflict with the decision of Subhash Chandra Maruaha. Subhash Chandra Maruaha deals with the right to be appointed from the select list, whereas K. Manjusri deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. So, my lord, as my lord made in the reference, if it is in respect of the procedure for selection, how to be selected, then, my lord, the retrospective amendment is permissible. Subhash Chandra Maruaha has been approved. Both the judgment has been approved, but on two different premises. And K. Manjusri, my lord, has also been approved by the Constitution bench, saying that basic qualification, eligibility criteria, once, my lord, selection commences, cannot be changed. my lord, I would hasten to add another judgment in the light of, my lord, these judgments. B. Swapna, my lord, of 2005 4 SCC, which says, unless, my lord, the rule prescribes, it cannot be applied, my lord, in a retrospective manner, because the rule is, my lord, required to be interpreted to be always to be prospective. And I take your lordships, my lord, to para 14.
Yes.
Para 14, my lord, the High Court has committed an error in holding that the amended rule was operative. As has been fairly considered by learned counsel for the respondent one, applicant, it was unamended rule which was applicable. Once a process of selection starts, the prescribed selection criteria cannot be changed. The logic behind the same is based on fair play. A person who did not apply because a certain criteria, for example, minimum percentage of marks can make a legitimate grievance. In case the same is lowered, he could have applied because he possessed the same percentage. Rules regarding qualification for appointment, if amended during continuance of the process of selection, do not affect the same. So amended rule cannot affect during the continuance of the selection process. This is because every statute or statutory rule is prospective unless it is expressly or by necessary implication made to have retrospective effect. Unless there are words in the statute or in the rules showing the intention to effect existing rights, the rule must be held to be prospective. If the rule is expressed in a language which is fairly capable of either interpretation, it ought to be considered as prospective only. So even if it is capable of being interpreted either way, then also your lordship will hold that this will have a prospective effect, unless it is expressly provided that it will have a retrospective effect. Now, I have already drawn your lordship's attention to the amended rule. It says, my lord, it will apply from the date of publication. So there is no express provision, my lord, for retrospective operation. Now, having said that, my lord, what was the stand of the, my lord, respondent department, my lord, before the honorable single judge? I take your lordships, my lord, to the counter affidavit, which starts from page 121. Here, two paragraphs may be, my lord, relevant. So I'll only draw your lordship's attention to para 6 and 8, madam. Page 123, madam. Para 6, my lord, the respondent DME, this is a affidavit of the Director of Medical Education Assam, arrayed as respondent 3, my lord. Basically, this is paragraph, my lord, only to draw your lordship's attention that, my lord, no formal order was passed, my lord, refusing the admission to the petitioner. Last 3 lines of para 6, my lord. The reason for rejection of the, no, my lord, I'll read the entire paragraph. That as regards the statements made in para 14 of the petition, here deponent states that the documents verification had been done in spot before the petitioner, and accordingly she was informed her non-eligibility of state health quota for admission in PG course in the medical colleges of Assam 24. The reason for the rejection of candidature of the petitioner was written in the body of declaration form by the board. So no formal order was issued. Now I take your lordships, my lord, to para 8. This is the, my lord, stand which they have taken, my lord, in their affidavit in opposition. That as regards the statements made in para 18 of the petition, your deponent states that the National Board of Examination published information bulletin for admission to MD, MS, PG diploma course for the 2024-25 session, inter alia, notifying the following important dates: online submission 16/4/24 to 6/5/24, issue of admit card 18/6/24, examination date 23/6/24, declaration of result 15/7/24. Subsequently, the Medical Counseling Committee, Government of India had published the Postgraduate Counseling 24 schedule and All India quota and says schedule PG 24 on 1st November 24 in its website for commencement of online counseling and admission for postgraduate courses session 2024. The Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Course 21, Amendment 24 was notified by notification dated 13/3/24 and the same was published in the official gazette on 13/3/24. Since the new amended rule has come into force with effect from 13/3/24, i.e. prior to the last date of submission of application with effect from 16/4/24, hence the Medical College of Assam Regulation Rules 21, Amended 24 is applicable for the candidates who has participated in the counseling process for admission into postgraduate courses in the Medical College of Assam for session 24-25. So in this para, they want to say that, my lord, since it has come into, my lord, force prior to the last date of submission of application, therefore, my lord, it will apply. This para is, my lord, contrary to the Constitution Bench judgment, which says these are merely stages, man. It does not initiate, my lord, the process of selection. Then I'll proceed further. It is further stated that the educational notice was issued by the answering respondent on 14/11/24, wherein it has also been specifically stated that the first round of counseling for admission into 50% postgraduate seats in the Government Medical Colleges of Assam and BCCI Guwahati under Assam State Quota for session 24 will be held as per the Medical Colleges of Assam Regulation Rule 2021, amended up to date. Subsequently, an admission notice was published on 26/11/24 inter alia, stipulating that all admissions shall be provisional and will be subject to fulfillment of all the requisite criteria as per the Medical Colleges of Assam Rules 2021, amended up to date. The petitioner participated in the admission and counseling process in terms of the said education notice dated 14/11/24 and admission notice dated 26/11/24 without challenging the terms and conditions of the said notices, and as such, at this stage, the petitioner is debarred from making the plea that the Medical College of Assam Rule 21, amended up to date, is not applicable for the candidates who has participated in the counseling process for admission into postgraduate course in the Medical College of Assam for session 24-25. So basically, in the second para, my lord, the stand is that, my lord, the education notice dated 14/11/24 and the admission notice dated 26/11/24, my lord, having specifically, my lord, stated that the amended rule will apply, and the petitioner not having challenged the same, accepting, my lord, the said, my lord, notices, participated in the selection process, now cannot challenge the same. This is, my lord, the ground, my lord, taken in the second para. So basically, my lord, there are two grounds. Firstly, my lord, this applies because the amended rule had come into force before the last date of submission of the application. This is their first, my lord, ground in para 8. And the second ground is both the notices, 14/11 and 26/11, not having challenge. Now the challenge does not, my lord, stand. So these are the basic, my lord, submissions of the department.
11 of
Now, my entire case was My lord, this submission, it has, my lord, crystallizes at para 20, page 81 of the writ appeal. And this is a ground on the basis of which, my lord, I stand. Para 20, page 81. It is not only a submission made before this honorable court, this is part of the pleadings, my lord. The statement and averment categorically made. This would be necessary because your lordship has to test it, whether this has been specifically denied by the respondent. May I read it, my lord?
Yes.
Para 20, page 81. That it is stated that the Medical Colleges of Assam Regulation Amendment Rules 24 is not applicable in the present case in connection with the petitioner admission, as the process of admission was started much before the rules of 2024 while rule was in force, and the initial notice was issued on 9/11/23 by the National Board of Examination in Medical Science, New Delhi, fixing the date NEET PG 24, and the Amendment Rules 24 came into force much after the process started of the admission in NEET PG 24. Therefore, the case of the petitioner may be considered under the rules of 2021. Now, your lordship will see whether or not this suffers from, my lord, non-traverse at page 1 to 26.
They have merely denied one line. Denied to be not true. Only
lord-
one line.
No, my lord, in fact, they have to say in a categorical manner, because this is, my lord, the point where the entire case hinges upon. They have to say that no, 9/11/23 is not the date from where the process, my lord, selection process starts. And they have to identify that date, that this is the date from this process starts. Now, what they say, my lord, at page 126. In view of statements made herein above, all statements made in paragraph 19, 20, this includes 20 also, 21, 23, 26, 27, 28, writ petition are being denied herewith. So, above para 9, they simply says that amended rule came before, my lord, the last date of application. They does not say that the selection process never started from 9/11/23. And this is not the date from where the process commences. And this aspect of the matter, in my respectful submission, my lord, has not been taken care of by the Honorable Single Judge. I'll come to the judgment of the Honorable Single Judge, my lord, right now. My lord, in this context, your lordship is aware. I'm not to burden your lordships, my lord, with the judgments. But when there is non-traversal, my lord, then your lordship has to presume that the statement or the pleadings, my lord, has been accepted by the parties. My lord.
Continue. Right.
Uh, Mr. Bora,
Yes, my lord.
please come to page 150.
Yes, my lord.
This paragraph 20 and 20 and 21,
115,
150.
150.
Next page to very good.
Yes, my lord.
Paragraph 20 and 21.
Yes, my lord.
Uh, with queries to both of you.
Right.
This there's a reference to notice dated 16/4/2024, both
Yes.
in para 20 and 21. Which
Yes, my
that
lord.
notification we are not finding it.
No, no.
My lord, I will show to your lordship, my lord. My lord, in my affidavit, my lord, which starts at page 122, my lord. The annexure A, your lordship will find at page 128, my lord. This is the information bulletin published by the National Board of Examinations, my lord. It stipulates in your page 129, your lordship will find that schedule. And our contention before the honorable single judge was there, the process started from publication of the information bulletin.
No, we are not on that. Only one question. Where is this?
My lord, may I clarify?
16,
Yes.
424.
Lordship is correct.
Page
My lord,
128, my lord.
this bulletin they have relied on. This bulletin is annexed, but
Page-
there is no notice of this bulletin. This
Page-
is, my lord, I say, my lord, in fact, this was an inadvertence.
Page
Please quote it,
128.
This, my lord, inadvertently quoted, my lord, in the judgment. There is no notice of 16.4. There is a bulletin of 16.4, but there was no notice of 16.4. my lord. In fact, my lord, the Central Government Counsel, Mr. K. Gogoi, he had informed the Honorable Court that, my lord, this bulletin was published on 16.4. So on that information, my lord, perhaps the Honorable Single Judge has recorded this, my lord, particular statement that there is a notice of 16.4. This is what I, my lord, submitted in the bar.
No, my lord. Actually, my lord, on that day, my lord, when Mr. K. Gogoi was asked two questions, my lord. When this information bulletin was uploaded in the official website, and regarding the earlier notice, my lord, or of 9/11, 8 or 9/11/2024, my lord, which was whether that was tentative or that was final. So he submitted that notification which was published in the month of November 2023, my lord. That was a tentative in nature, and this information bulletin was uploaded in the official website on 16/4/2024. And along with that,
appears to be incorrect.
Yes, my lord.
Appears to be incorrect.
No, my lord. That is, he has verified it from the authorities, my lord. On that particular day, he verified it from the authorities. It was uploaded on the official website on 16/4/2024. And a notice was also produced before the Honorable Single Judge.
My lord, my learned friend is
16/4/2024.
merits of the
You
case.
just see from here,
Yes, my lord.
this is the internet.
Yes.
18/024. Progress. Hello. No, you see, I'll give you this. One is in purple.
Yes, my lord.
Below that, you will find the date of uploading. It is 16th of April.
Yes.
Sorry, 18th.
Yes.
The bulletin is 16th,
Yes, my lord.
but it is uploaded on 18th. Purple.
Yes, my lord.
You see the date, 18th April. Right? Down below. Third one
Yes, my
is
lord.
purple. Down below, after that, you will find,
Information bulletin, my lord.
down below here, opening date, you will find 18/4. Correct? Now, when you open this is a 115-page
Yes,
bulletin.
my lord, I have got it. But from here, we cannot ascertain the date because it was published on 18 June 2024. 18 June, my lord. The news was published on 18 June. 18/6/2024. But from the information bulletin, we could not ascertain, even from our authorities of the Director of Medical Admission, I could not ascertain. That's why, my lord, the assistance of the Central Government Council was sought for. He directly contacted with the respondent number 2, who published this information bulletin, who uploaded. From there, he confirmed and categorically stated before this honorable court that it was uploaded on 16/4/2024.
16/4.
Yes, my lord.
Okay.
The news was published on 18/6/2024, my lord.
Yes.
Yes, my lord, may I continue, my lord? My learned friend will have his turn. Yes, my lord.
Yes,
Correct.
my lord.
My lord, in respect of non-traverse, I have, my lord, placed the judgment 2007, 3 Supreme 794. My lord, this is by the Honorable Supreme Court. So if your
Which one?
lordship,
That I supply.
Which citation?
my lord, 2007, 3 Supreme 794. I have supplied before your lordship, my lord. 2007, 3 Supreme 794. Supreme today AI, my lord. Petitioner?
No.
My lord, para 11. Honorable Supreme Court says there was no denial of the assertions made by the appellant.
2007 is, there's one 2020, that
No, my lord.
Dr. Major Mita Sahai.
No, Mita Sahai, my lord, is, I'll come to that, my lord, later on. Mita Saha.
I think we have 3 citations before us.
One
One is 2005-4, one is 2024. That this Tej Prakash Pathak, and third is Nita Sahai.
My lord, this is M. Venkataraman Hebar.
No, it's okay. Give us the citation.
There are. No, only I am trying to show that when there is a non-traversal, your lordship will, my lord, take inference that the same has been admitted. This is a settled proposition of law. I am need not, my lord, place, but though, my lord, I am placing it. And in fact, orders 8 Rule 3 and order 8 Rule 5 of the CPC has been mentioned. And I take your lordships to para 12. Thus, if a plea which was relevant for the purpose of maintaining a suit had not been specifically traversed, the court was entitled to draw an
That
inference.
is order, because of order 6 Rule 5.
Oh,
It's a
yes,
pleading
but-
simply cited in a civil suit.
My lord, correct, my lord. But order 8 Rule 3 and order 8 Rule 5 is, my lord, quoted here by the Honorable Supreme Court.
Yes.
Denial to be specific and specific denial. These are mentioned. I'm only trying to say when there is a, my lord, no specific denial, so therefore it is hit by the doctrine of non-traversal. And therefore your lordship will take an inference that the plea has been admitted. Now, having said that, one another aspect, my lord, which that I would like to draw your lordship's attention, that the initial which notice, my lord, of 9/11, even if, my lord, this notice is not taken to be the date of initiation of the, my lord, selection process, but the notice, my lord, next page, 9 January 24, that has to be taken to be the initiation of the selection process, which has come into force before the amendment, my lord. Because what I find, that the earlier notice 9/11, that was superseded by the subsequent notice 9 January 24. And here, by this notice, the date was rescheduled 7 July 24, and the cutoff date was 15 August 24. So if your lordship does not accept that the initial notice, my lord, was not, my lord, the notice by which the process was initiated, because it was eventually superseded, then, my lord, 9 January would be the date. Subsequent to this, my lord, notice, the process was initiated. Now, if I take your lordships, my lord, to the operative part of the judgment, which starts, my lord, from para 13 of the, my lord, impugn judgment, my lord, impugn order, at page 147. The issue has been, my lord, discussed in para 13, and thereafter I'll come to the relevant part of the judgments, my lord. 147, para 13. The issue that has to be decided in this writ petition is whether the tentative notice dated 9/11/23 or the information bulletin containing the notice dated 16/4/24, both issued by the respondent 2, would be the dates from which the admission process would have commenced. Thereafter, whether the rules of 21 or the amended rules of 24 would be applicable will have to be considered by this court. So therefore, whether the notice or whether the information bulletin, because the respondents, my lord, had relied on the information bulletin saying that this would apply because the dates of submission of application, the date of, my lord, the holding of, my lord, the examination and the declaration of result are specified, my lord, in the information bulletin. Now, from para 17 onwards of the, my lord, impugned order at page 149, my lord, would be relevant. If your lordship comes to page 149, para 17. Coming to the issue in hand, a perusal of the notice dated 9/11/23 clearly indicates that it is a tentative notice, and the schedule of NBEMS examination scheduled in the first half of the year 24 is also tentative in nature. In other words, it would mean that the notice is not definite or positive and purely tentative in nature. So, my lord, the Honorable Single Judge holds that, my lord, this is a tentative notice, because the reasoning was that the date, my lord, which is indicated therein, my lord, is a tentative date, and the notice also spells out, my lord, that it's a tentative notice. And page 94, the respondents had relied on, my lord, the subject of the notice, saying that subject reads as follows: tentative schedule of NBEMS examination scheduled in the first part of year 2024. So the submission was that since the date is tentative, so therefore the notice is also tentative, it cannot be relied on. This was, my lord, the submission. Now, if your lordship goes to para 17, the Honorable Single Judge has invariably said that's a tentative notice, but no reason has been assigned why this notice could not have commenced, my lord, the selection process. So the question is, if the date is tentative, whether the notice it can be brushed aside, or the notice it can, my lord, it itself can be ignored. Man. So this notice was not relied on by the Honorable Single Judge on this ground that the date, my lord, of the schedule of examination was tentative. Now your lordship will come to para 18. Coming to the information bulletin, which is annexed to the affidavit in opposition filed by the respondent number 3 as Annex RA, it is seen that information bulletin also contains the notice dated 16/4/24. Para 18, my lord. Information bulletin also contains the notice dated 16/4/24, wherein applications were invited for national eligibility cum entrance test and postgraduate NEET PG 24. A reading of the same would therefore indicate that the notice dated 16/4/24, which was issued by the respondent 2, is not a tentative and it is a definite nature. Therefore, in the considered opinion of the court, this notice dated 16/4/24 would be the date from which the admission process would have commenced. Now, firstly, my lord, the Honorable Single Judge has referred to a notice, my lord, 16/4/24, which is not part of the records. So what the notice indicated, my lord, we don't know, number one. And number two, my lord, there is no reasoning why the Honorable Single Judge holds that this is a definite notice, but not a tentative notice, my lord. So whether, my lord, the Honorable Single Judge, by referring to, my lord, this particular, my lord, information bulletin of notice dated 16/4/24, whether the Honorable Single Judge has brushed aside the earlier notices of November 23 and January, my lord, 24. There is another notice of January 24, is at page, my lord, I have already drawn your lordship's attention, is at page 95, my lord. The earlier, my lord, November notice was superseded, and by this notice, my lord, the selection process was initiated, fixing the cutoff date as 15 August 24 for the eligibility, and fixing, my lord, the date of conducting, my lord, examination 7 July. So therefore, by heavily relying on, my lord, the information bulletin, along with the notice 16/4, which is not part of the records, the Honorable Single Judge, my lord, has ignored the earlier notices by which, my lord, the selection process was initiated. Those notices have been totally brushed aside, my lord. It has not been taken into consideration. And in my respectful submission, my lord, this part of the reasoning, it runs contrary to the Constitution bench judgment. If the date of application, schedule of examinations, or holding of the examinations, my lord, are required to be commencing, my lord, the selection process, that runs contrary, my lord. Because the Constitution bench has held, these are my lord, stages of the selection. This cannot, my lord, initiate the process.
Yes.
My lord, I would hasten to add that so far as the information bulletin is concerned, at page 129, if your lordship comes to page 129, 29, my lord.
Yes.
Date of examination date, scheduled as 23rd June 24. If the same reasoning is applied, that on this date also, the examination was not held, then the entire reasoning goes, my lord. If the date of the examination, my lord, is the basis for coming to a conclusion that on that date, my lord, the notice, my lord, indicating the date, if it is final, then it is a notice which commences, my lord, the selection process, then this date is also, my lord, not final, because eventually the examination was admittedly held on 11/8/24. The date specifying, my lord, in the information bulletin is also tentative, my lord, on which, my lord, the Honorable Single Judge has relied on. So in my respectful submission, the reasoning, my lord, at para 18, with all respect, my lord, it runs contrary to the Constitution bench judgment, and therefore, my lord, this is not, my lord, sustainable. With all humility, my lord, I am submitting. Because, my lord, here it was a case not to determine which notice is tentative or which is final. The issue was whether the amended rule will apply in the case or not. Selection process having initiated by the November 23, which was superseded by the January, my lord, notification. So therefore, essentially, it has to be held that either November, if your lordship does not accept November, then it will be the January notification. Subsequent thereto, my lord, there are no other notifications, my lord, superseding the initial notice. So therefore, whether or not the, my lord, selection process commenced from January, before coming into force, my lord, of the amended rule. If at all your lordship does not accept, my lord, the notification of November 23.
There is no retrospective provision.
In that view of the matter, my respectful submission, the selection process having been initiated prior to, my lord, the amendment of the rule of 24, therefore it could not have been given a retrospective effect. Acceptance, my lord, of applications, date of scrutiny, holding of examinations, my lord, are part of the selection process. And referring to those dates, my lord, in my respectful submission, one cannot say that the selection process commenced, my lord, from this particular date.
Yes.
My lord, my another respectful submission was before the Honorable Single Judge that the notices subsequent to the November notices, including the information bulletin, those are supplementary and complementary notices. Those only supplement and complement the initial notice commencing the selection process. And this, my lord, particular submission, in my respectful submission, was not considered by the Honorable Single Judge.
Yes.
The Honorable Single Judge, my lord, in my respectful submission, does not assign any reason why the information bulletin commences, my lord, the selection and not the earlier notices, either the November 23 notice or the January notice. Why those two notices does not commence the selection process, my lord, there is nothing, my lord, in the, my lord, judgment of the Honorable Single Judge. And why the information bulletin has been relied on, it is also bereft of reason. Why that is the basis, my lord, for the commencement of the selection. Para 17 and 18, at least, my lord, it is not discernible from these two paragraphs. Now, if your lordship comes to para 19 of the judgment, sorry, not 19, my lord, yes. 19, my lord. This court having come to the conclusion that the notice dated 16/4/24 would be the date when the admission process has commenced. The next issue is whether Rule 21 or amended Rule 24 would be applicable to the candidates seeking admission to NEET PG examination in the government colleges of Assam and BBCI Guwahati for the session 24. So therefore, my lord, the Honorable Single Judge has come to the conclusion that the notice 16/4, which is not part of the records, rather the Honorable Single Judge had indicated the information bulletin specifying the various dates. My lord has come to the conclusion that this is the date from where, my lord, the process commences.
Is the copy of Assam Medical Colleges regulation is available here?
Yes, it is part of the records. I have drawn your lordship's attention, my lord. The Rule 21 rule as well as the amended rule, my lord.
No, the entire rule.
Entire rule is there, my lord. The entire rule starts from, my lord, page 104, my lord. It ends at 117. This is the entire rule of 21.
Okay.
And the amended part starts from 118, my lord.
Okay.
Because since, my lord, it relates to SHU quota, State Health Service quota, so therefore I had drawn your lordship's attention to Rule 7, which is the relevant rule, my lord. Rule 21, it says 5 years or more experience in rural areas. And the amended rule says continuous service of 5 years, as on 31st May of the, my lord, year of admission. So in para 19, my lord, apart from assigning no reason why the information bulletin or the notice dated 16/4 would commence the process, apart from, my lord, bereft of reason, this paragraph, my lord, also runs contrary, with all respect and humility, to the judgment of the Honorable Supreme Court, the Constitution Bench judgment, which says that these are mere stages, man. Once it commences, there can be no retrospective application of the amended rule. And my learned friend, on being asked, my lord, had informed the Honorable Court on the bar that except the petitioner, there is no other candidates who is aggrieved and have approached before your lordship's mind. Only one candidate. In my case, my lord, this has been rejected. Now your lordship will come to para 22. This is the another reasoning on which, my lord, my writ petition has been dismissed. May I read it, my lord? The submission of the Learned Standing Council, Health Department, that the educational notice 14/11/24 as well as the admission notice dated 26/11/24, this is the ground which they have taken in affidavit in opposition, my lord, prescribing that counseling for admission and admissions will be subject to the fulfillment of requisite eligibility criteria as per the rules of 21 has been considered by this court. There is no doubt that both educational notice dated 14/11/24 and admission notice dated 26/24 clearly prescribe the applicability of the amended rule of 24. Now, my lord, this is the reasoning on which, my lord, which forms the ground of rejection also. The petitioner being fully aware of the applicability of the amended rules of 24 in both the education notice dated 14/24 and admission notice dated 26/24, 11/24, and having already participated in the admission process, cannot be permitted to turn around and claim that her candidature is governed by rules of 2021. And thereby, the Honorable Single Judge, on these two grounds, that it starts from, my lord, the date of the notice 16/4, rather the information bulletin, and, my lord, she is debarred from challenging the same, having participated, my lord, in the admission process, the writ petition has been dismissed.
Yes, conditionally select.
My lord, my respectful submission is, in respect of para 22, that the principle that a candidate, my lord, who participates in the selection and afterwards, when he is unsuccessful, he cannot turn around and challenge the selection, is a principle, my lord, which is not inflexible. I'll place, my lord, two judgments, one of the Honorable Supreme Court and another of this Honorable Court. My lord, in 2005, Honorable Justice Ranjan Gogoi had passed the judgment saying that, my lord, the facts and circumstances, my lord, will depend on. And secondly, when the challenge is in respect of a statutory rule, either misconstrued or applied in a, my lord, wrong manner, then the challenge will sustain. You cannot challenge only when you have challenged the marking, giving the marks that this has been wrongly given, or you are challenging the constitution of the selection committee. Then you cannot challenge because you are fully aware. Here is a case, my lord. I have been placed in a select list on 26/11, 24. Then I have to appear on 29th. My lord, can I abstain myself from appearing before the selection, my lord, board? Then they will come and say that his case was not considered. She did not appear. So whether my participation will debar me, my lord, under these present facts.
Listed me in this document.
I am, my lord, the number 1 in the select list, so far as the quota is concerned. Now, the Supreme Court judgment, which I have already placed before your lordship, my lord, that Mita Sahai's case. This is a recent judgment, my lord, 2019, 20 SCC 17. If your lordship comes to para 17. My lord, 17, here the principle has been, para 17 principle has been quoted. Mita Sahai, 2019, 20 SCC, page 17. Para 17, my lord, it is stated as thus, it is well settled that the principles of Estoppel prevents a candidate from challenging the selection process after having failed in it as iterated by this court in a plethora of judgments, including Manish Kumar Sahai. My lord, this part may not read. My lord, this principle has been laid down. So, what is the underlying objective? Then down the down part of that reference, my lord, the quoted, my lord, extract. The underlying objective of this principle is to prevent candidates from trying another shot at consideration and to avoid an impasse wherein every disgruntled candidate, having failed the selection, challenges in it the hope of getting a second chance. Now, para 18 is relevant. However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. I have accepted the procedure, my lord, not the illegality. In a situation where a candidate alleges misconstruction of statutory rules, this is in my case, my lord, and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless she participates in the selection process. If I don't attend in the, my lord, selection board, before the selection board, the plea would be she has not come. So how can I abstain myself, my lord, from participating thereof? And my participation will not preclude me from challenging the same, my lord, in terms of the judgment of the Supreme Court.
There's another query
My lord.
with what you have submitted.
My lord.
Can you come to please come to page 110?
110.
In this rules,
My lord.
for the purpose of notification,
My lord.
only rule 12 has that notification for counseling.
My lord.
Correct.
My lord.
Now, if you can turn over
My lord.
the page 111
My lord.
is rule clause B,
My lord.
allotment of seat by counseling.
Yes.
Correct.
My lord. My lord. Correct.
Then 18
My lord.
at page 112, rule 18
My lord.
is subsequent counseling.
My lord.
Correct.
My lord.
Now please come to 21,
My lord.
page 113,
My lord.
appeal.
Huh.
And then second, you are referring to interpretation is 23, interpretation of any clause of these rules.
My lord.
And then there is a power to relax, 24,
My lord.
and page 113.
My lord.
Now, in this context, what do you have to say?
Yes. My lord, in fact, so far as the counseling, my lord, notifications are concerned, those are issued by the DME after the select list is prepared. Once I, my lord, figure into the select list, then I will be called for the counseling. So rightly it has been done in that case, my lord. Education notice and admission notice are the, my lord, by the notifications under, my lord, rule 12. These are done. And secondly, my lord, my respectful submission so far as the appeal before selection committee is concerned, here, my lord, this particular provision will not debar me. This is a, my lord, alternative remedy, I understand. But alternative remedy will not debar me, my lord, from participating, my lord, from coming before your lordships, my lord. Your lordship is aware of various decisions, including world food. If my fundamental right under Article 14 is violated, irrespective of the alternative remedy, my lord, I can approach before your lordships, my lord. And my lord, here, medical admission cases are done in such a, my lord, haste, or rather in a such a, my lord, speed manner. My lord, if I wait for, my lord, the counseling, I file, my lord, representation there, my lord, entire seats would be filled up, and my lord, I will have no remedy. And your lordship is aware, once the seats are filled up, even if my writ appeal is allowed, my lord, I miss the bus. I'll be nowhere, my lord. Supreme Court has held, once the last date of admission goes, last date, then you cannot be accommodated. Lordship is aware. So in this context, my lord, I have approached before your lordships. Now the other, my lord, judgment of the honorable, my lord, this honorable court, your lordship will find that para 10, I will not burden your lordships. My lord, the same principle has been applied in 2005 3 GLR 659, my lord. That is at para 10. Because if you participate in the selection, you cannot challenge subsequent thereto is not an inflexible, my lord, proposition of law. This is Devaranjan Soikia's case, my lord, 2005 3 GLR 659. Para 10, my lord, this principle has been laid down. And the Honorable Court says that subsequent judgments of the Supreme Court makes it clear that this principle is not inflexible, my lord.
Relaxation part of the 31st May. September come to
And this particular judgment, my lord, of 2005 has been relied on in another judgment. I will not burden your lordships, my lord. 2014, 1 GLR 152, that is Bipul Datta. Same principle has been laid down. So the ground, my lord, assigned, my lord, and para 22 by the honorable single judge may not be sustainable in view of this, my lord, settled proposition of law. And my lord, only one last point. My lord, since I have started with the submissions that the cutoff date is 31st May. Normally, this happens as the admissions, my lord, takes place by 31st May. And the classes commences from, my lord, June. Here is a case that the admission will, my lord, come to an end by 29th of, my lord, this month, December. So if the cutoff date is accepted to be 29th of December, by, my lord, by November, my lord, 24, I have a continuous service of 5 years, irrespective of the earlier 1 year, my lord. So there is another, my lord, this is another ground which was not, my lord, considered by the honorable single judge, and I have taken this ground in my reply also, my lord.
You take a break and come back.
My lord. Yeah.
So I have obtained a copy.
I'm copy मुझे दिया
ठीक है आपको मुझे दिया
हाँ दिया सर
कीमत तो हम इसको
Yes.
So, my lord, in the writ petition, we have filed our affidavit, my lord. Mainly, we are relying our case on two grounds, my lord. Firstly, my lord, our contention is that, my lord, The notice which was published in the month of November 2023, my lord, that was a tentative notice, my lord. That was tentative in nature, my lord. Page 94, the learned counsel for the petitioner has been relying on, my lord. The notice dated 9/11/2023 issued by the National Board of Examination. And here it has been specifically stated that tentative schedule of NBEMS examination, wherein, my lord, the various examination to be held under the NBEMS was notified, my lord. But our contention is that the process starts, my lord, from the date when the information bulletin or notice for has been published. The which is like the advertisement, my lord. It has been published on 16/4/2024 only, my lord. And that information bulletin we have annexed, my lord. Your lordship will find at page 128. And since we did not have the copy of the notice issued by the National Board of Examination, so that notice was produced by the Learned Counsel for the Central Government, Response number 2, which shows that, my lord, actually, my lord, that notice was published or uploaded in the official website only on 16/4/2024 only, my lord. Inter alia stipulating all the terms and conditions, because the earlier notice, my lord, 9/11/2023, that has been subsequently superseded by very other notification, my lord. But that cannot be treated as an advertisement, or the process of examination has started from that date, my lord. Because nothing has been mentioned, no stipulations, how it will be conducted, my lord. Nothing was mentioned in those notifications, my lord. So our contention is that the process starts from 16/4/2024 only, my lord.
Yes.
And in support of our contention, I would like to rely upon a decision of the Supreme Court, my lord.
Environmental person.
2019 10 SCC, page 20, my lord.
Eligibility criteria. Saya muncul itu mulai dari terus udah semua.
Para 7 of this judgment is relevant, my lord.
And BT himot lagi. Gimana pera gimana bisa?
7.
7. He's concerned.
Yes.
Para 7, my lord.
Para 7.
7 of the judgment, my lord, I have put it, my lord.
Oh, acha. This Vidhi Himmat.
Yes, my
Kataria.
lord. Yes, my lord. Para 7 is relevant, my lord. It is mainly contended on behalf of the petitioners and it is submitted by the learned counsel appearing on behalf of the petitioners that the NEET UG 2019 brochure was released on 1/11/2018 and the notification amending regulations 1997 whereby Appendix H is added to the erstwhile regulation 2017 has been issued on 4/2/2019. The case of the petitioners are required to be considered as per the provisions prior to 4/2/2019 and more particularly prevailing as on 1/11/2018. The aforesaid has no substance. The relevant essential eligibility criteria is required to be considered when the petitioners were to get admission in the MBBS course under PWD quota. It is required to be noted and so stated in the reply affidavit filed on behalf of the MCI that the expert committee submitted the report guidelines for admission of persons with specified disabilities which was placed before the executive committee of the council in its meeting held on 5/6/2018. Wherein after due discussion and deliberation, it was decided to approve the same. It was also decided that the said expert committee report should be communicated to the Ministry of Health and Family Welfare in view of the schedule for counseling for admission to MBBS course for the academic year 2018-19. However, for admission for the academic year 2018-19, it was at the stage of a draft notification and the Graduate Medical Education Regulation 1997 were not amended in light of the recommendation of the expert committee constituted by the MCA which has issued the disability guidelines. This court directed to give admission as per the unamended Graduate Medical Education Rules Regulation 1997. However, subsequently and before the admission for the academic year 2019-20 are given, notification dated 4/2/2019 has been published and the Graduate Medical Education Regulation 1997 have been amended as above. Therefore, in the facts and circumstances of the case, it cannot be said that rules of the game are changed midway, as sought to be contended on behalf of the petitioners. As observed herein above, the essential criteria as per Appendix H is required to be considered at the time when the candidates were seeking admission in the medical course under PWD category. It is also required to be noted that even the candidates seeking admission in PWD quota are required to appear before the concerned medical board at the time of actually seeking admission and after NET result is declared. So the principle is held that, my lord, therefore, the relevant date for considering the essential eligibility criteria as per Appendix H shall be the date on which the candidates petitioners sought admission in the MBBS course under PWD quota. So it says that date on which admission is sought, my lord, the date of submission, last date of submission of the application, my lord. In my humble submission, so the date which has to be considered is that the date when the last date of submission of application has been fixed. And our contention is that the amended rule came much prior to that in the month of March, 13/3/2024. So therefore, my lord, on the last date of submission of the application, the amended rule was there. So amended rule will be applicable, my lord. And my second round of argument is that, my lord, even if, my lord, suppose if your lordship holds that, my lord, the petitioner is eligible for admission under the unamended rule, but, my lord, in the writ petition, my lord, first thing is that she has participated in the counseling process without raising any objection to the earlier notice, my lord, the educational notice and admission notice, which clearly states that the admission process will be held in terms of the amended rules, my lord. There are two notices, my lord, your lordship will find at page 130 and 132, my lord. 130 Annexure B to my affidavit, my lord. Page 130, my lord. So this is the educational notice published by the respondent number 3. Here, my lord, in second paragraph, your lordship will find the first round online counseling for admission into 50% postgraduate seats in the government medical colleges of Assam and BBCI Guwahati under Assam State Quota for session 2024 will be held as per the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Courses Rules 2021 amendment up to date. So it says that the amended rule will be applicable. It is the educational notice. Thereafter, my lord, the admission notice was published. This educational notice was dated 14/11/2024. Subsequently, my lord, the admission notice was published on 26/11/2024 at page 132, my lord.
Page 132.
Page 132, my lord.
Yes.
After the table, my lord, date and time revised date, then my lord, 1, 2, 3, 4, 5, then the paragraph starts, my lord, after verification of the documents, the selected candidate shall have to get admitted in the respective allotted.
This does not have a date.
My lord, it was published online, my lord. But in our paragraph, my lord, I have specifically given the date, my lord.
What is the date?
26/11/2024, my lord. In para 8, my lord, I have specifically given the date, my lord.
There is a page?
Page 132 page.
No. In your para 8
yes,
of your
that is, my lord, as page 24, my 124.
Okay.
So this admission notice also specifically stipulated that after verification of the documents, the selected candidates shall have to get admitted in the respective allotted institutions on 4/12/2024 to 5/12/2024 with following terms and conditions, failing which their allotment will be cancelled. So very first clause says that all admissions shall be provisional and will be subject to fulfillment of all the requisite eligibility criteria as per the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Courses Rules 2021 amendment up to date. So it also stipulates that amended rule will be applicable. The petitioner participated in the process, my lord, in terms of the educational notice and admission notice. And she never raised any objection regarding this, my lord, applicability of the rule. Only when she has been rejected due to non-fulfillment of 5 years continuous service, now she is taking this plea, my lord. Even if, my lord, in the writ petition, if your lordship comes to the prayer portion of the writ petition, her simple prayer is to allow her. Her simple prayer is to allow her the state health services quota for the session 2024, my lord. But, my lord, fact remains that the entire process has commenced and is going on in terms of the amended rule, my lord. If that remains, how she can be admitted? She has not, even in the writ petition also, she has not challenged the validity of this educational notice and admission notice. As long as, my lord, educational notice and admission notice is there, the rule of amended rule of 2024 will be applicable. And she cannot get a seat under the amended rule of 2024. She has not challenged this educational notice and admission notice, my lord. If it is her contention that amended rule shall not be applicable, the earlier rule has to be applicable. In that case, she should have challenged the admission notice and educational notice.
No, not required.
No, my lord. Because the process is continuing, process has commenced and
No, if the plea is that the particular criteria.
Yes, my lord.
Will not apply to him. There's
Yes,
no
ma'am.
reason to challenge it because the petitioner is of a view
Yes, my
that
lord.
this will be applying prospective and therefore doesn't cover me. So
My
there's
lord,
no point
in
of
the
challenging that.
prospective part, I'm not contesting, my lord. But it is prospective in nature, that is admitted. But my lord, that part, that stipulating that which rule will be applicable.
The challenge would mean that the
Yes.
petitioner is aware of the amended criteria which is affecting her.
Yes, my lord.
So she's not aware that it is
Not
affecting her.
that part, my lord. The educational notice and admission notice which stipulates that amended rule will be applicable.
That's why we are saying.
Yes, my
You
lord.
see, if it doesn't apply, there's no reason to challenge it. This
And
will be challenged only when
as
the
long as
petitioner is
that-
aware.
As long as, my lord, educational notice and admission notice there, my lord, she cannot be admitted because that education notice and admission notice
That Mr. Bora is itself the challenge.
yes, my
That
lord.
whether in this notification of
Yes.
admission,
Yes, my lord.
whether these amended rules would apply or not.
Yes, my lord.
So that itself is a challenge.
Yes, my lord. That is true, my lord. And so she participated in the selection process, my lord, without challenging or without raising any objection to that proposition, my lord.
Yes.
So my submission is mainly on these two grounds, my lord. First is that the process started from publication of the advertisement on information bulletin with effect from 16/4/2024. The last date of application, online submission of application was 16 April to 6 May 2024. That is, so in my humble submission, the rule which has come into force much prior to that, my lord, on 13/3/2024. So amended rules will be applicable. And second ground is that she has participated in the selection process in terms of the education notice dated 14/11/2024 and admission notice dated 26/11/2024, wherein it has been specifically stated that amended rule will be applicable. She has not raised any objection or challenge to these two notifications now. And she has participated, my lord. Only when she has been rejected, now she is challenging. So on these two grounds, in my humble submission, there is no infirmity in the judgment and order dated 18/12/2024.
Let us assume for the time being
Yes, my lord.
that we accept your contention.
Yes, my lord.
In that event, please come to page 113.
Yes.
The government has a power to relax. Now,
Yes,
who
my
would be the appropriate government then?
Government in the middle. Relaxation.
My lord, the rules are
What-
framed by the Commissioner
what-
Secretary, Medical Education and
Yes, my lord.
Research.
Government in the medical education and research.
Medical
department.
education.
Yes, my lord.
Page 120, my lord, the
Yes, my lord.
signatory,
100?
120. Who has
Otherwise also,
issued
my
the
lord,
rule, my lord.
government in this regard will be the government in the medical education and research department, my lord.
Okay. Yes, that's all.
Yes, my lord.
Well, only one line. The judgment which has been referred to by my learned friend, this is before the Constitution Bench judgment. And the judgment is very clear. It is with respect to the eligibility criteria. It is not in respect of, my lord, application of a, my lord, amended rule in a retrospective manner. And my case, this, my lord, judgment supports me. Because when I applied, my lord, on 16/4, I assume, my lord, that as you could not have applied in a retrospective manner, so I am guided by 21 rules, unamended rule. So it supports me, my lord. This is a judgment which, my lord, rendered in a totally different premise. It is with regard to eligibility criteria. And my judgment, constitution-based judgment, with regard to application, my lord, of amended rule in a retrospective manner, while, my lord, when the, my lord, selection commences from the date of initial advertisement or notice. And these are various stages, my lord, in between. I'm obliged. But my only prayer is, since your lordship, my lord, has referred to the relaxation part, if your lordship refers the matter, my lord, to the government, Then one seat, my lord, in the radiology department, my lord, at Silchar Medical College, that may be kept vacant, my lord. If they fills up the case, my lord, seats, then my lord, I'll be nowhere, my lord. This is my humble submission.
A query. This is the initiation is by the National Board of Examinations
Yes, madam.
or in medical sciences, correct?
Yes, madam.
Now they make a selection, they give a select list.
Yes, madam.
Yes,
Correct.
no dispute with that.
No, NEET, my
And
lord.
now for the state quota, the state quota is dependent on the state government notification,
Yes, my lord.
correct?
Yes, my lord.
Okay.
State quota, my lord, for the purpose of counseling only. Otherwise, examination, entire examination is
So,
done
and
by the.
examinations they can't handle.
Yes.
So it is only for the purpose of counseling and allotment of seats.
Yes, correct, correct.
And
Okay,
admission.
okay, okay.
Está sintiendo গাধাৰ মাজত থাকিবই সিহঁতক সন্তুষ্ট কৰিব সিও বেয়া পাব নিদিলেও বেয়া পাব
Heard Mr. S.K. Talukdar, learned counsel for the petitioner, sorry, appellant, also heard Mr. D.P. Bora, learned standing counsel for the health department, representing respondent numbers 1, 3, and 4, and Ms. R. Devi, learned CGC appearing for respondent number 2. Next, brother. This intra-court appeal is presented against the order dated 18/12/2024, passed by the learned single judge in WPC 6434 of 2024, thereby dismissing the writ petition. Next para. In brief, the case of the appellant is that she is an MBBS doctor who is aspiring for admission in postgraduate medical course. Full stop. The petitioner had served at Mesalkhoa, MESSELKHOWA, MPHC, Agia, AGIYA, not comma, Agia, BPHC of Gwalpara district under 1 year compulsory rural posting from 9/4/2018 to 8/4/2019. Full stop. Thereafter, the petitioner was appointed as medical and health officer Roman 1 at Garajan, GARAJAN SD at Nagaon, by notification dated 23/10/2019, pursuant to which the petitioner has joined the said post on 31/10/2019. Stop. Next para. On 13/3/2024, the The government amended the Assam colleges of medical colleges of Assam within bracket regulation of admission into postgraduate degree and diploma courses bracket closed rules 2021 within bracket 2021 rules. In exercise of power under Article 2309 of the Constitution of India, which was published in the Gazette of in the Assam Gazette Extraordinary, dated 13/3/2024, and the comma, which is the date by virtue of which the medical colleges of Assam within bracket regulation of admission into postgraduate degree and diploma courses bracket closed within bracket again amendment bracket closed rules 2024 came into effect. Full stop. The relevant rule nine within bracket Roman 1 small, which is the subject matter of no, which has come up for its mode of application on the petitioner is quoted below. This you'll find from the from page 148 from earlier judgment. You have to just quote from there. It would also be appropriate to quote here in below the unamended rule 7(1)(c). This also you will find at para 15, page 147. You have to quote from there. Next para. Next, the case of the petitioner is that on 9/11/2023, notice was issued by the National Board of National Board of Examinations in Medical Sciences, New Delhi, under the subject in inverted commas, tentative schedule of NBEMS examinations scheduled in first half of year 2024, inverted comma closed, full stop. This is at page 94, by which the postgraduate NEET examinations were scheduled from, which is the date?
My lord, 3rd March 24.
Okay, the 3rd March 2024. Full stop. Thereafter, by a subsequent notice dated 9/1/2024, the date of conducting of NEET-PG, 2024 was rescheduled from 3/3/2024 to 7/7/2024. Full stop. Later on, by another notice dated 5/7/2024, the revised schedule for conduct of NEET-PG, 2024 was rescheduled to 11/8/2024 in 2 shifts. Full stop. Next paragraph. Accordingly, the petitioner offered a candidature for the said examinations, and having scored 79.9461779, she was placed at rank 43393. Full stop. The petitioner got provisionally selected for MD course in radio diagnosis at Silchar Medical College as a full stop. The petitioner projects that she's a top rank holder as per the select list dated 26/11/2024.
Against my lord, the SHQ quota,
Against state
health service quota.
health service quota within bracket SHQ for short, bracket closed. Full stop. The petitioner projects that the first counseling was held on, what is the date?
My lord, in fact, the select list was issued on 26/11.
Counseling on 28 and 29. Select one of the education person is a nutrition selection. Purpose.
So this 26/11 will do, counseling is not required. We
Yes.
can omit that in the order.
Yes, yes.
Yes,
My lord, that date of verification, page 101. After the dates are indicated, my lord.
28/11.
Yes, this was my lord, I was called on 29/11. This is my,
Okay,
since my
okay.
rank is 574.
Okay. Mr. is also projected that in terms of the admission notice
26/11, my lord.
dated 26/11/2024, the candidates appearing at serial number 5 to 262 were called for counseling on 28/11/2024, and candidates at serial number 265 to 1577 were called on called for counseling on 29/11/2024, and accordingly, the petitioner was ranked at serial number 574. Underwent counseling on 29/11/2024. Full stop. In course of counseling, comma, wherever I said petitioner, make it appellant. Uh, the appellant was informed that she does not fulfill the 5-year of continuous service clause, which was the amendment carried on in 2024 to the 2021 rules. Full stop. Accordingly, the appellant has approached this court by filing WPC 6434 of 2024, whereby the petitioner is called upon for issuance of a mandibus to direct the respondents to allow the appellant for provisional admission into postgraduate courses in Silchar Medical College, Silchar, under the SHQ for the session 2024 against the seat for which he was selected in the provisional select list dated 26/11/2024. Next paragraph. Give a heading, contention of the learned counsel for the appellant. Next paragraph. The learned counsel for the appellant contends that usually the admission into postgraduate courses in medical sciences are completed within the month of March 2024.
May, my
May 2024.
of the academic year.
May 2020, sorry, within the month of May of the academic year. And accordingly, while the state government brought in the amendment to Rule 7 by notification issued on 13/3/2024, the process of admission had already begun by issuance of notice dated 9/11/2023. Stop. Accordingly, it is contended that the amendment would not be applicable on the petitioner, as the amendment would operate prospectively, and therefore, in respect of the process which was initiated on 9/11/2023, the amendment notified on 13/3/2024 would have no application. Full stop. It is also contended by referring to the case of Tej Prakash Pathak versus Rajasthan High Court, within bracket 2024, bracket close 0, Supreme within bracket SC 1001, that the initiation of the admission process having commenced on 9/11/2023, the various dates of the beginning and end date of applications, scrutiny, and the NEET-PG examination dates are merely various steps in the process of admission which cannot be applied for which the amendment by notification dated 13/3/2024 would not apply retrospectively, as the petitioner already had 1 year of rural service from 9/4/2018 to 8/4/2019, and with effect from 31/10/2019 to
Till date, my lord.
till date. No, on that day you said 1 year, 4 months, 5 year, 4 months, 4 days.
That
Where is
certificate, my lord, at page, my lord, 293. This is
90.
on 211. It says 5 years, 4 days. 5 years, 4 days. Page
Okay.
93 and extra 5.
Because as on uh,
November.
as on
2nd November 24.
2/11/2024, the petitioner had rendered rural service for a period of 5 years, 0 month, 4 days
Continuously.
continuously. First, accordingly, it is submitted that even if the date of application is considered, which will deem to have, on which date the petitioner, the appellant would be deemed to have less than 5 years of continuous service, but she has a qualification of 1 year of rural service from 9/4/2018 to 8/4/2019, and therefore there being no necessity of a continuous 5-year service as per the 2021 rules, the petitioner, the appellant is still qualified with the required numbers of years of rural service. Next paragraph. It is contended that the various dates given in the notification being only stages, the learned single judge had ought not to have rejected the contention of the appellant on the ground of applicability of the notification dated 13/3/2024, as the said legal proposition, accepted by the learned single judge based on the decision of the Supreme Court of India in the case of Vidhi VIDHI, Vidhi Himmat, HIMMAT, Kataria, KATARIYA, and others versus State of Gujarat and others, within bracket 2019, bracket close 10 SCC 20, is would run counter to the ratio laid down in the case of Tej Prakash Pathak within bracket Supra. Next para. It is also submitted that the learned single judge had relied on notification dated 16/4/2024 to be the notice issued on to be a notice issued on the said date, which is not borne by the record. And moreover, there's nothing on record to show that the process was not initiated wide notice issued on 9/11/2023. Full stop. Next, in support of his contentions, comma, the learned counsel for the petitioner has also placed reliance on the following cases. These cases are here applied serially here, and there are two decisions of Guwahati High Court that will come at the end. Make aside. Only one decision of Guwahati High Court will come in and keep in serial order. These are, apart from one already stated, the others are 1, 2, 3, 4 more cases, apart from one already cited. 5 cases total. Next paragraph. Contention of the learned counsel for the learned study counsel for the health department of the state. Mr. Talukdar, anything I've left out?
Oh, more or less, my lord, that
Yes, sir.
it may not have a retrospective effect unless expressly provided, that I have submitted, my lord.
That we have already stated, no retrospective effect. That we have already
Correct,
stated.
correct.
Okay. Contention also. Next, the learned study counsel for the health department has submitted that the submission of online applications commenced from 16/4/2024 by virtue of a notice issued by the National Board of Examinations in Medical Sciences, New Delhi, a copy of which has been a copy of the first page whereof has been produced for the perusal of this court. And it is submitted that the various dates which were provided in the notification dated 19/11/2023 9/1/2024 and 9/1/2024 were only tentative, and therefore they said notification would have to be construed to be only a tentative notification, and that after the petitioner has, after the appellant was selected in the NEET, the state government's criteria for allotment of state state
Health service quota. State health service quota.
state health service quota would be applied, which was already in place by the amendment notification dated 13/3/2024. Full stop. By referring to this is next paragraph. By referring to the educational notification issued by the Director of Medical Education Assam on 14/11/2024 and admission notice issued by the same authority subsequently for the document verification clearly indicated that the admissions shall be provisional and will be subject to fulfillment of all the requisite eligibility criteria as per the inverted commas medical colleges of Assam within bracket regulation of admission into postgraduate degree and diploma courses bracket closed rules 2021 within bracket amendment up to date inverted comma closed full stop. So accordingly, it is submitted that the applicant was fully aware of the criteria required for her selection and admission into the PG courses in the medical college in Assam under the state health services quota. It is SHQ.
SHQ, but the definition is in the rules, my lord. State
Health services quota.
Yes.
Okay. No, we take.
Yes, yes, ma'am.
Full stop. In support of his contention that the rules on the rules applicable on the date of admission would apply, reliance is placed on the decision of three-judge bench of the Supreme Court of India in the case of VIDHI, Himmat HIMMAT, Kataria within bracket Supra. Next paragraph. Reasons and decision heading. Next paragraph. We have perused the memo of writ appeal, writ petition and documents appended thereto, affidavit in opposition filed by the respondent number 3, along with documents appended thereto, as well as the affidavit in reply. You have filed an affidavit in reply also.
Yes, my lord. Fine.
It's at which page?
That starts, my lord, from page, my lord, 134, my lord.
134.
My lord.
Which are, affidavit in reply filed by the petitioner. Filed by the appellant in the all in the proceedings in the writ petition. And you have also carefully perused the decision cited at the bar. Next paragraph. The The notice dated 9/11/2023 issued by the National Board of Examinations in Medical Sciences is under the following heading. You just give a dash, subject, colon, tentative schedule of NBEMS examinations scheduled in first half of year 2024. Full stop, inverted comma closed. And as per the said notice, comma, it is provided that the NBEMS shall be conducting the following examinations as per the calendar mentioned below until any further updates. And the candidates are advised to check the exact dates of examinations from the information bulletins / NBEMS website, as the above dates are purely tentative and subject to approvals and confirmations. Full stop. Right. As per the contents of the notice dated 5/7/2024, comma, the same is under same is with subject, colon, revised schedule for conduct of NEET-PG 2024, whereby it is informed that that in continuation of the NBEMS notice dated 22/6/2024, comma, the conduct of NEET-PG 2024 examinations have been rescheduled to be conducted on 11/8/2024. And it is also provided that further details regarding the conduct of examination in 2 shifts shall be published on NBEMS website in due course. Just give you a set name also. NBEMS website, https:// 2//natboard.edu.in in due course. Full stop. We also take next paragraph. As the learned single judge had taken note of the notice dated 16/4/2024, in paragraph 20 and 21 of the impugned order, comma, on a perusal of the copy of notice dated 16/4, copy of first page of notice dated 16/4/2024, comma, produced by the learned standing counsel for the health department, comma, it is seen that the said notice, that by the said notice dated 16/4/2024, it is with subject, colon, applications invited for national eligibility cum entrance test dash postgraduate with NEET dash capital PG bracket close 2024 dash regarding inverted comma closed. Full stop. The said notice contains information about the dates, important dates, comma, visited VIZ. Number 1, availability of information bulletin from 16/4/2024 onwards. semicolon. Number 2, online submission of the application form, give a dash or semicolon, colon, whatever. 16th April 2024, within bracket 3 p.m. onwards, bracket closed, to 6/5/2024, within bracket, till 11:55 p.m. bracket closed. Again, semicolon. Number 3, date of examination, give a dash or colon, whatever. 23rd June 2024, semicolon. Number 4, declaration of result, semicolon, column, by 15th July 2024. This is the document. Stop. The examinations were done as per the schedule? No.
No, my lord.
Stop. The
Examination, date of examination was subsequently changed, my lord.
okay.
Stop.
11th August. man.
11.
We also take into consideration that even the dates given in the said notice dated 16/4/2024 were rescheduled,
Only the
and-
date of examination. my lord.
and no, everything will change.
No, my lord, or date of
Also,
examination.
oh,
only.
okay. And insofar as the date of examination is concerned, comma, the NEET-PG examinations are stated to have been held in the month of August,
11 August.
on 11 August 2024. Espera. However, comma, we take note of the fact that they said notice dated 16/4/2024 is available in the internet and the NEET-PG, 2024 information bulletin is also available in the website of the National Board of Examinations for the 24/25 session. Full stop. Therefore, comma, for all intents and purpose, comma, the court is unable to accept the contention of the learned counsel for the petitioner, for the appellant, that the initiation of the process of NEET-PG examination has to be held to have been initiated on 9/11/2023 by the issuance of notice dated 9/1/2024. Full stop. The reason to take this view is because of the fact that in the notice dated 9/1/2024, the same appears to be a notice for conducting of the NEET-PG, 2024 examination, wherein the dates given are tentative and and the said notice also contains at clause 5 thereof to refer to NBEMS website for information, bulletins, application form and other details. Full stop. even on perusal of the notice dated 5/7/2024, which was in which contained revised schedule for conduct of NEET PG, 2024 examination. The same is in continuation to notice dated 22/6/2024. And in the said notice also, and clause 4 thereof contains reference to the publication of the conduct of examination in 2 shifts in the NBEMS website in due course. Next paragraph. The court takes note of the submissions made by the learned standing counsel for the health department that it is pursuant to the notice dated 16/4/2024 issued by the National Board of Examinations in Medical Sciences, New Delhi, that the initiation of the process of admission had begun, and that the information bulletin, which was followed, was uploaded on 16/4/2024. The online submission of application forms was between 16/4/2024 to 6 May 2024, and that the examinations were held subsequently, i.e. 11/8/2024 instead of the notified date of 23/6/2024 as per notice dated, which was notified in the notice dated 16/4/2024. Full stop. Therefore, on this count, the court is unable to find fault with the finding of the learned single judge as regards the as regards the notice issued on 16/4/2024 by the respondent number 2, inviting applications for NEET PG, 2024. Next paragraph. Notwithstanding the eligibility of the petitioner in the NEET PG examinations, 2024, for the purpose of seats under the state health services quota, the respondent authorities are bound by the 2024 amendment to the 2021 rules, which was carried out and given effect to from 13/3/2024, the date of its publication in the Assam Gazette. Therefore, when the educational notice dated 14/11/2024 indicated that the admissions will be held as per the 2021 rules, which is amended up to date, which is repeated in the subsequent notification fixing the date of counseling, the court is of the unhesitant view that the amended criteria under the notification dated 13/3/2024 would be applicable. And therefore, on that count also, we do not find any infirmity in the decision of the learned single judge that as Rule 7 within bracket Roman 1 bracket close small c was amended by the amended rules of 2024, which was notified in the Assam Gazette on 13/3/2024, the said amended rules would be squarely applicable for the petitioner and also for the concerned authorities during the counseling session. Therefore, the ratio laid down in the case of Vidhi Himmat Kataria within bracket Supra is found to be correctly applied by the learned single judge. Next para. Coming to the decision of the Constitutional Bench of the Supreme Court of India in the case of Tej Prakash Pathak within bracket Supra. The court has no quarrel with the ratio laid down in the said decision, which involves recruitment process and the ratio laid down therein that eligibility criteria for placement in the select list cannot be altered after the recruitment process has commenced. The said ratio cannot be applied under the facts and circumstances of the present case in hand, because in the present case, the notice inviting applications was issued on 16/4/2024 by the National Board of Examinations in Medical Sciences, New Delhi. The application by the petitioner, appellant, for a postgraduate seat under the NEET PG 2024 would have to be applied under the notification dated 16/4/2024 and brochure or information bulletin issued thereafter. In this regard, we have already held in the preceding paragraph, in the hearing before, that the notice dated 9/11/2023, as well as 9/1/2020, 9/11/2023 and 9/1/2024 and 5/7/2024. No, sorry, no, only two. 9/11 and 9/1 are only tentative. And it is clearly mentioned in this said notice that the dates are purely tentative and subject to approvals and confirmations. Full stop. There is no material on record that the said schedule was approved and confirmed because it is not in dispute that the NEET-PG examination was, selection examination was held only on 11/8/2024. Next para. Under the circumstances, though the petitioner, though the appellant had served at MESSEL, MESSEL, KHOWA, MPHC, Agya, BPHC of Gwalpara district from 9/4/2018 to 8/4/2019 under 1 year compulsory rural posting program, and had subsequently served as medical and health officer -1 at Garajan, GARAJAN, SD, Nagaon from 23/10/2019 till date, and had rendered 5 years, 0 month, 4 days service as on 2/11/2024, yet by the cutoff date of May 2024, the petitioner did not have 5 years of continuous rural service, which means 5 years service without any break in service. Stop. Next, therefore, we do not find any reason to interfere with the impugned order dated 18/12/2024, passed by the single judge in WPC 6434 of 2024. Next para. However, before parting with the records, we take note of the provisions of Rule 24 of the Medical Colleges of Assam, within bracket, regulation of admission into postgraduate degree and diploma courses, rules, 2021, which provides to the state government a power to relax accordingly, taking note of the fact that the appellant had secured is projected to have secured top position for
State.
MD course,
SHQ quota.
MD course under State Health Services quota in the radio
Diagnosis. Diagnosis, my lord.
radio diagnosis
Yes, department.
department at Silchar Medical College. comma. The court is inclined to provide that in the event the petitioner, the appellant submits a representation to the appropriate government in the appropriate government, i.e. the secretary to the, principal secretary to the government of Assam, health and
Family welfare.
welfare.
My lord,
No,
it
no.
will be Commissioner and Secretary, Medical Education and Research
Okay, just
Department.
write that.
Page
Please repeat
1.
again.
Commissioner and Secretary, Medical Education and Research Department.
Research department. Uh, this today it can be done.
Yes, my lord, you can file it today.
You can do it today. It can be by email. You have the email address? No.
No. By email, we don't have the email, my lord.
You can get it.
But it will be better if they can file it physically because email, my lord.
By tomorrow, my lord.
10:30.
Tomorrow is a open working day for the department.
Tomorrow is Tuesday.
Please find out
Yes, my lord.
and
Right.
tell us.
My lord, today is the result date, 23/12. Subsequent admission notice says today is the result date. So second counseling ended tomorrow, yesterday.
Second calling
Yes, and the-
done yesterday.
Yes, yesterday ended, my lord, and today is the result date. So, my lord, may I have an observation that until, my lord, representation is, my lord, disposed of, one seat in the radio diagnosis may not be filled up, my lord. Otherwise, my lord,
It is possible.
yes.
Tomorrow is working day, my lord.
Tomorrow is working day.
Yes, my lord.
Result is 23, that is
20
today.
Today, my lord.
Okay. In the event the petitioner submits a representation for relaxation to the so and so, comma, the said authority shall take a decision. Okay, it can be there, it can do it tomorrow also.
Yes, my lord.
Huh?
Yes, my lord, because the urgency is there, my lord.
In course of we will say that it's submitted within 12 a.m. 12 noon on tomorrow, that is 24, or the said authority shall take an immediate decision in course of 24/12/2024 and intimate the result thereof to the petitioner in email address to be provided in the representation. So therefore, till disposal of the representation on subject to submission of representation and disposal thereof on 24/12/2024, comma, the seat of the postgraduate seat of
Radio diagnosis, my lord.
radio diagnosis in Silja Medical College shall not be declared, which is otherwise scheduled to be declared on 23/12/2024 as per educational notice issued on 10/12/2024. Next para, the learned standing counsel for the respondent for the health department shall verbally communicate this order to the
To
director of
the
medical,
Director of Medical Education.
to the
Director of Medical Education and Commissioner and Secretary
to
to
the
the
Commissioner Secretary to the Government of Assam, Medical Education
and Research Department.
and Research Department, as well as to the Director of Medical Education Assam, to be followed by communication of a scanned copy of the
Yes,
order. Okay,
My lord, I will send one email or by email also. I will send one representation by email also, my lord, by today or in the morning tomorrow. If my learned friend provides me the email, my lord, that your lordship may, my lord.
okay. Just
My
write
lord,
it down with that email address.
my lord, the physical copy
No,
will
I will-
help.
physically I will
because
file, my lord.
otherwise the
No, no,
email.
physical copy also takes time
Yeah.
from the
Yes, my lord.
gate to go to.
It will
the-
be
No, my
because
lord,
12
by
noon I have
12,
to.
as your lordship has indicated, because it will be beneficial for her.
No, he's saying as
Both.
additional.
Both,
Yes, yes.
He's
additional.
saying both.
Yes, my
So give
lord.
it to him. Find it
I'll
out,
have
give
to
it to him.
find out, my lord.
Because the document from go to gate to the officer may take some time.
Yes, ma'am.
No, my lord, the person concerned herself can go and submit it,
She
my
will
lord.
go.
Okay.
Additionally, my lord, she will file.
Because, my lord, I have the official email address. So even if I give it, my lord, if it may lie in
Yeah,
the,
once you tell them, they will definitely take care.
Yes,
Well,
my lord.
this notice is coming. Share it with them.
Email address to दिया वो.
Option
मतलब
numbers.
format decide हाँ.
It will be easier
yes, my lord.
at times.
Yes, my lord.
Okay.
I'm my lord grateful for patient hearing. My lord, this certified copy I need not. I am required to submit along with the representation, my lord. If I get, my lord, from the court master this true copy, then it will help me, my lord. Yes. My lord.
Right.